A 12-year-old girl was handed a worthless piece of paper as a joke, and 23 years later, that joke cost a corporation $4.2 million and counting. What do you do when the most powerful man in the room underestimates the quietest person in it? Donaldson picked up on the second ring. His voice was already wrong. Too fast, too high. The kind of voice a man gets when he hasn't slept, and the reason he hasn't slept is sitting in a county records file he should have read 3 years ago. "The project is frozen," he said. "The whole northern corridor. We can't move a single truck." On the other end of the line, a lawyer named Price set down his coffee and said nothing for 4 seconds. That was how you knew it was bad. Price never went 4 seconds without talking. "The access road," Donaldson said. "It's not ours." Price said a name, Nora Vance, and the line went quiet. Rewind. 13 years back, the Callaway County auction ran on a Thursday with 4 plastic folding tables, a coffee pot that had been burning since 7 in the morning, and 11 people who came mostly out of habit. The old Vance farm was going for parts. The equipment went first, then the storage buildings, then the land itself, lot by lot, while a man named Briggs stood near the back wall in a jacket that cost more than the coffee pot and everything it had ever brewed combined. Harlan Briggs, VP of Meridian Land Holdings, 44 years old, confident in the specific way that men get when they have never been wrong about money in front of anyone who mattered. He had been buying up tracts along Route 9 for 8 months. The Vance farm was the last piece. Once he had it, he had everything he needed to build his northern corridor, a mixed-use development that would pull 300 jobs and $40 million into a county that hadn't seen either in a generation. Briggs had already told the mayor. He had already told the paper. He had already told his wife. What he had not done was read the deed. Not all of it. Nora Vance was 12 years old that Thursday. She sat in the second row between her mother and a metal chair nobody was using. With a spiral notebook on her lap and a pencil she kept turning over in her fingers. She had dark eyes and she did not fidget. She watched Briggs the way a person watches a clock, not with feeling, just with patience. Her father's name was on the defaulted notes. Her family had lost the farm 6 months before, but they were still here because Nora had asked to come, and her mother had learned by then that when Nora asked to be somewhere, it was usually for a reason she hadn't explained yet. The auction moved through its lots. Briggs nodded once, and the bidding on the main acreage was done before most people had finished their coffee. He got 280 acres for $618,000. The county took its cut. The bank took the rest. Then the auctioneer cleared his throat and mentioned, almost as an afterthought, that there was one remaining recorded item, a narrow access easement on the northeastern edge of the property, 12 feet wide, running 340 feet from the county road to the old equipment yard. Originally filed in 1961, administratively renewed in 1978 under a State Preservation Act, not attached to the main deed, technically still on the books as a separate recorded interest. Nobody bid. Briggs laughed, out loud. Not meanly, just carelessly, the way a man laughs at something that is too small to take seriously. He walked over to where Nora was sitting and pulled a folded document from his coat pocket. It was the easement transfer, a single page, signed by the county clerk and stamped in blue ink. His own lawyer had told him it was worthless, an administrative ghost, a filing error from 1978 that carried no real value because the road had no commercial use and the easement could not be developed, only accessed. Briggs dropped it onto Nora's notebook like he was tipping a busboy. "Tell your dad the farm gave him one last thing for free," he said. "Frame it." He was already half turned away when he finished the sentence. Nora's mother started to speak. Nora put 2 fingers on her arm, light as a held breath. Her mother stopped. Nora picked up the document. She looked at it for a moment. Then she folded it once more, along a crease that was already there, and slipped it into the back cover of her notebook without a word. Briggs walked back to his associates near the coffee pot. He said something. They laughed. 4 people in that room watched Nora receive that document. None of them remembered it afterward. That was fine. Nora didn't need them to remember. She already knew that the 1978 Rural Access Preservation Act contained a single subsection, Section 78-114, that made an administratively renewed easement irrevocable without a formal county public notice and a 90-day objection window. No notice had ever been filed. The easement was alive, and she was the only person in the room who had read that far. Hit subscribe right now, because what Nora finds in that library is the kind of thing that was sitting in plain sight for 63 years, and nobody saw it coming but her. Callaway County Public Library, 14 months before the auction. The map was in a box marked discard. It was a 1961 county survey, folded wrong, faded at the creases, and it had been sitting in a rolling cart near the back of the reading room, because the head librarian was culling the archive, and nobody had asked for a county survey from 1961 in 11 years. Nora had asked for it at 10:15 on a Saturday morning. She was 11. She had her notebook. She had a pencil. She had a library card she had used 47 times in the past school year, more than anyone else her age in Callaway County, which was not a fact she advertised. The librarian brought her the box. Nora opened it and got to work. The survey showed something that wasn't on any current county map. A line, thin, penciled, running northeast from Route 9, across the top edge of what was then the Vance property. The label beside it said, Corridor Access, Reserved. Below that, in smaller letters, Pending Route 9 Expansion, Do Not Develop. See Resolution 14B. Nora wrote down Resolution 14B. She spent 40 minutes looking for Resolution 14B. It took 3 Saturdays. She found it in a bound county record from 1963, a proposed road expansion that would have widened Route 9 northward and required a dedicated access corridor through the Vance property's northeast corner. The resolution had passed, the road expansion had not. Funding ran out in 1965, and the project was quietly shelved. But the resolution was never formally canceled, and the corridor it created, 12 feet wide, 340 feet long, was renewed administratively in 1978, when the state passed the Rural Access Preservation Act. Under that act, any corridor or easement filed before 1975 and not formally vacated was automatically renewed on the public record and could only be removed through a county notice and objection process. No notice had ever been filed for the Vance corridor. Nora wrote Section 78-114 inside the front cover of her notebook. She underlined it once. She didn't say anything to her parents that week. Her father was deep in the default negotiations, and the house was quiet, in the way houses get when adults are worried and trying not to show it. Nora set her notes in a folder. She put the folder in her desk drawer. She went back to the library the next Saturday and pulled the county tax rolls. The easement had been assessed separately from the main Vance parcel since 1983. The county had been issuing a small annual tax bill, $47 a year, against the corridor as a distinct recorded property interest. 40 years of $47. That small bill meant the county itself treated the corridor as a real taxable piece of land. You cannot tax something that doesn't legally exist. Nora wrote the number down. $47. 40 years. She did the arithmetic in the margin. Then she went home. The kettle was already on when she got there. Her mother, whose name was Deb, was at the kitchen table reading a utility bill and not really reading it. Nora spread her notebook open next to the fruit bowl and began drawing a map, the Vance property, the corridor, Route 9, and a dotted line showing where a developer would eventually have to cross that 12-foot strip to get from the highway to the interior acreage. There was only one logical entry point to the northeastern section of the property. The corridor sat directly across it. Deb looked at the map for a moment. "What is that?" she asked. "A road that never got built," Nora said. Deb looked at her the way she sometimes looked at Nora, like she was trying to read a book she hadn't been given the title of. She didn't ask more. She put a mug of tea next to the notebook and went back to the utility bill. That was enough. Over the next 7 months, Nora watched. She rode her bike past the Vance property 14 times. She noted the survey flags, small orange markers staked along the property line in 3 separate sessions, each one pushed a little further north. She noted the truck, a white pickup with a Meridian Land Holdings magnetic sign on the door, idling at the shoulder of Route 9, while a man inside made phone calls and took photographs of the field. She wrote down the truck's plate number. She wrote down the dates. She went to the county clerk's office and asked the clerk, a tired woman named Patrice who was eating a sandwich, whether the public could see LLC property acquisition filings. Patrice pointed to a terminal in the corner without looking up. Nora sat at the terminal for an hour. In 11 months, a company called Meridian North LLC had acquired 6 parcels along the Route 9 corridor. They were all purchased through different sub-entities, names that didn't sound like they were related, but that shared the same registered agent address in the same city. She drew the parcels on her map when she got home. 6 rectangles, 1 missing. The Vance farm, still in default, still unsold. And across the top of the Vance farm, a thin dotted line, 12 feet wide, 340 feet long. The one piece of Route 9 access that connected all of Meridian's assembled land to the highway. Without that corridor, a developer with 6 purchased parcels had land they could not legally access from a public road. Without legal access, they could not permit. Without a permit, they could not build. Nora looked at the map for a long time. She closed the notebook. The trap was already set. She just had to wait for someone to walk into it. $47,000. That was the number the young agent said when Nora opened the front door on a Tuesday afternoon in May, 16 months after the auction. He was polished, clipboard, blue tie, the kind of smile that had worked on a lot of front porches. He said he represented a regional land interest group. He said $47,000 was a very fair number for a 12-foot easement with no commercial use. He said she could have a check by Friday. Nora was 14. She was holding a glass of water. She thanked him. She said no. She closed the door. He stood on the porch for a moment before he left. She watched him through the side window and wrote the date in her notebook. She mowed the corridor strip twice a year, May and September. She used a push mower on the 12 feet of scrubby grass, and she walked the full 340 feet each time, making sure the survey stakes at both ends were still clear and visible. The annual tax bill came every February, $47, and she paid it in cash at Patrice's window before the end of the month. Every year, on time. The second contact came by phone, 18 months after the agent, a man who said he was from the county's Economic Development Office. Very courteous. He explained that a project of significant regional interest had run into a minor title complication, and the county was prepared to facilitate a voluntary resolution for $138,000. He said voluntary. He said facilitated. He said minor. Nora asked if the county had filed the public notice required under Section 78-1114. There was a pause. He said he'd have to look into that. She said thank you, and she hoped he had a good evening. He did not call back. She told Deb about the second call at dinner that night. Deb looked at her for a moment. How much longer? Deb asked. However long it takes, Nora said. Deb nodded slowly. She refilled her own glass. She didn't say anything else, because by that point she understood enough. Not every detail, not the legal subsections, but enough. Enough to know that Nora had been right about everything so far, and that the offers getting larger was not a sign of generosity. It was a sign of panic. Their daughter Iris was 7 that year. She came to the corridor strip with Nora one September afternoon, while the mowing was happening, and asked why this piece of grass was special. Nora stopped the mower. "It knows where it is," she said. Iris looked at the strip, then at the field beyond it, then at the highway in the distance. "Okay," she said, and went back to kicking rocks. Somewhere across the county, in a conference room on the 4th floor of an office building, a lawyer named Fitch was on a phone call that was not going well. Meridian had been paying holding costs on 6 assembled parcels for 2 years. Interest alone was running $31,000 a month. Permits couldn't move without proof of legal highway access. And the access sat in a 12-foot strip that a 14-year-old girl was mowing with a push mower and refusing to sell. Fitch had tried an agent. He had tried the county. He had tried 2 different letter-writing campaigns that Nora had responded to with single-paragraph replies, citing the same statute and the same tax record and nothing else. He paged Briggs. Briggs said, "Send someone in person." The lawyer who came in person was not young and not polished. He was 51, wore a 3-piece suit, and carried a leather briefcase that he set on the kitchen table before he sat down. His name was Fitch. Nora poured him coffee without being asked. He laid out Meridian's position. The project, the jobs, the county impact. He said $340,000 was an extraordinary offer for a strip of ground that had never had a building on it. He said Meridian was prepared to be generous because they understood the history of the Vance farm, and they felt a responsibility to the community. Nora let him finish. She said, "Is Meridian prepared to file the Section 78-114 public notice to vacate the easement?" Fitch looked at his briefcase. "Because if they're not," she said, I'm not sure what we're negotiating.
He said he was authorized to go to $400,000.
She thanked him for the coffee and stood up. Fitch drove 3 hours back to the city and told Briggs in a 2-sentence email that there was no number that would work, and they needed a different approach. Briggs replied in 1 sentence, "Find a legal angle." The legal angle arrived as a filing, an abandonment claim. Meridian's new brief argued that because the corridor had not been used for its stated purpose, road access, in over 60 years, it had been legally abandoned and should be removed from the public record. Fitch filed it on a Thursday. By Friday morning, it was in the county clerk's system. By Saturday morning, it was in Nora's notebook. She read the filing twice. She made 1 phone call. The call lasted 4 minutes. Then she set the phone down on the kitchen table and looked at the hand-drawn map pinned to the wall. The 6 Meridian parcels, the corridor, Route 9, the dotted line she had drawn 6 years ago. The phone rang. Unknown number. Nora looked at it for a moment. She picked it up. Fitch's voice was careful, measured. The kind of careful that men practice when they know they've run out of better options. He said Meridian was prepared to resolve the abandonment claim through negotiation rather than litigation, and that his client had authorized a final offer of $620,000. Cash, clean title transfer, 90 days to close. Nora was 25. She was standing in the same kitchen. The hand-drawn map was still on the wall. She said, "I'll call you back." She hung up. Iris drove down that Saturday. She was 20 now. She had finished her 2nd year of property law. She pulled into the driveway at 11 in the morning with a file box on the back seat and 3 red pens in her pocket. She spread everything across the kitchen table. The original 1961 survey, the 1978 renewal stamp, the county tax rolls going back 42 years, $47 a year, every year, never missed, all 42 receipts, in a folder Nora had kept in the top drawer of the kitchen desk. She read for 2 hours without saying anything. Deb put the kettle on. Iris finally looked up. "This is the one they can't beat," she said. She pointed to the tax rolls. "The county taxed this strip as its own parcel for 42 years. You can't abandon property the government kept billing you for. The county's own records destroy the claim." Nora nodded. "I know," she said. Iris looked at her. "You've known this the whole time." Nora picked up her coffee cup. "Since the library," she said. Iris made the call back to Fitch on Sunday afternoon. She introduced herself as Nora Vance's daughter and legal representative. She told Fitch that the abandonment claim would not survive a hearing because the county had assessed and collected taxes on the corridor parcel in 42 consecutive years, and that she had 42 receipts to prove it. She also told him that Nora was not interested in a lump sum sale. Fitch said, "Then what does your client want?" Iris looked at the notebook on the table, at the folded document in the back cover, the same sheet Briggs had dropped on a 12-year-old's lap 13 years ago, still sharp at the creases. "A permanent monthly access license," she said, "non-transferable without consent. Inflation adjusted every 3 years. And it goes to her heirs when she's gone." Fitch said that was not a standard arrangement. Iris said, neither was handing a 12-year-old a legal document as a joke. There was quiet on the line. The hearing happened on a Wednesday. Callaway County Courthouse. Room 4. A county hearing officer named Judge Bremer, who had been on the bench for 19 years and had seen most things. Fitch's team had 3 lawyers and a title researcher. They presented the abandonment argument. 63 years of non-use, no road ever built, no corridor ever physically traveled. Iris placed 3 documents on the table without standing up. The 1956 origin filing, the 1978 renewal stamp, the folder containing 42 years of tax receipts. She said 8 words. The county kept billing it. It was never abandoned. Judge Bremer looked at the tax receipts for 45 seconds. He ruled for the respondent. Meridian's lead attorney reached for his phone before the gavel came down. Fitch called back that evening. His client would accept terms. He pushed back on the inflation clause. Iris held it. He pushed back on the air transfer provision. Iris held that too. He asked if Nora would accept $2,800 a month to open. Iris put him on hold. She walked to the kitchen. She said, $2,800 to start. Nora was at the table with her coffee. $3,000, Nora said. Iris went back to the phone. $3,000, she said. Adjusted every 3 years, minimum 4%. Transferable to heirs. Monthly, First of the month. Fitch was quiet for a moment. Done, he said. Iris called Nora with the news that night. Nora picked up on the second ring. How'd it go? She said. Every term, Iris said. Nora was quiet for a moment. Okay, she said. That was all she said. Deb heard her hang up from the next room. She put the kettle on without being asked. She didn't say anything. She had been not saying things in exactly the right moments for 13 years, and she was not going to break the streak now. The signing was at the county clerk's office on a Thursday. Patrice, the same clerk who had eaten a sandwich while an 11-year-old found an LLC registry on a public terminal, stamped the documents without recognizing Nora. That was fine. Nora walked to her truck afterward. She sat in the driver's seat. She opened the notebook, the same notebook, the one with the map in the middle, and the statute number on the inside cover, and the folded easement document still tucked in the back. She turned to the last blank page. She wrote one line, $47 a year for 42 years, then $3,000 a month for the rest. She closed it. 3 days later, a small item ran in the Callaway County Gazette, 4 sentences. It noted that Meridian Land Holdings had finalized an access agreement for its Route 9 corridor project, and that construction permits were now moving forward. Harlan Briggs read it at his desk. He did not comment. The 4 people who had been at the auction 13 years ago, the ones who had watched a grown man drop a document on a 12-year-old's notebook and laugh, went about their lives without quite knowing what they had witnessed. Nobody laughed now. Some men collect land. Nora Vance collected patience, and it paid her $3,000 a month for the rest of her life. Would you have taken the $620,000 that morning, or held out for the monthly deal? Drop your answer below, and if you made it this far, you already know which one Nora would pick.